petitions number 14, 15, 16, 18, actually 85 of 2023, as read out, is ready, and the court has given one court judgment. It is over 200 pages. We have chosen to read a summary of the judgment, but the judgment is ready for the parties and the advocates and will be dispersed to them immediately after reading the summary. This is the summary of the court judgment. Introduction. This consolidated petition essentially challenges provisions of the Anti-Homosexuality Act for the alleged contravention of human rights and freedoms that are guaranteed under the Uganda Constitution and international human rights instruments, which Uganda is a party. The petition is opposed by the Office of the Attorney General, Messrs. Martin Semper and Stephen Langa, and the Family Life Network Limited. It did also benefit from an amicus brief filed by the Secretariat of the Joint United Nations Program, HIV/AIDS. The parties framed the 14 issues for the court's determination. 5 of the issues were procedural and 9 were substantive. Issue number 1, alteration of previous court decisions. 1. The petitioners contend that the enactment of the Anti-Homosexuality Act 223 had the purpose, objective, and or effect of altering the earlier decisions of this court, which they quote. This is alleged constitute a violation of Article 95 of the Constitution. 2. In Professor J. Oroko Nyango and others versus the Attorney General, the court adjudged the Anti-Homosexuality Act of 2014 to have been passed without the requisite quorum. Given that no determination was made as to the constitutional rights of the petitioners in that case, it cannot be suggested that the current Anti-Homosexuality Act changes or obliterates undeclared rights. Similarly, the Kasha Jacqueline case did not interrogate the constitutionality of homosexuality vis-a-vis the fundamental rights and freedoms enshrined in the Constitution. It follows, therefore, that the current Anti-Homosexuality Act would not, ipso facto, negate the legal rights of litigants in that case. The Victor Juliet Mukasa case was equally steeped in human rights violations rather than homosexuality per se. Therefore, the current Anti-Homosexuality Act would not necessarily abbreviate the trial court's decision. We find that the enactment of the Anti-Homosexuality Act of 2023 did not have the effect of altering previous court decisions. Consequently, the Anti-Homosexuality Act was not passed in violation of Article 92 of the Constitution. Issue number 1 is therefore resolved in the negative. Issue number 2, charge on the consolidated fund. The majority position in Mali H. Marilizi and others versus the Attorney General Consolidated Constitutional Appeal number 2, 3, and 4 of 2018 and reported was that Article 93 prohibits charges on the consolidated fund that cannot be accommodated within existing budgetary provisions. In this case, it has not been demonstrated by the petitioners that the implementation of sections 16 and 17 of the Act would impose a charge on the consolidated fund or alter any existing charge. The argument that the prison service, probation, social and welfare officers would be paid for the man-hours spent rendering rehabilitation envisaged under Section 16 is speculative and not supported with proof that the necessary public servants would in fact be paid on man-hour basis rather than within the pre-existing, pre-budgeted, and unaudited prison service wage bill. 5. In Marriage Mabilizi versus the Attorney General, the majority position was that the amendment to the original bill that had the effect of creating charges on the consolidated fund could be severed from the resultant act as opposed to striking down the entire act on that account. It follows, therefore, that had the petitioners in this case proved that Section 16 that was introduced to the bill by way of amendment did in fact create a charge on the consolidated fund, it would have been liable to suffer the same fate of severance from the Anti-Homosexuality Act. However, insofar as clause E and F of the certificate that was availed in this case do indicate that expenses from the Anti-Homosexuality Bill could be accommodated within the budgetary framework for the period in question, they do comply with Section 76(2) of the Public Finance Management Act. To that extent, the Certificate of Financial Implications does abide the dictates of Article 93 of the Constitution. In the result, we find no violation of Article 93A(2) of the Constitution. Therefore, issue number 2 is resolved in the negative. Issue number 3, public participation in legislative processes. Article 36(1) of the Uganda Constitution recognizes Ugandans' right to participate in the governance of the country, either individually through a referendum or by representation through their elected representatives. We do not construe Rule 109 of the Parliamentary Rules of Procedure to impose a constitutional obligation upon Parliament's Committee on Legal and Parliamentary Affairs to undertake the extensive consultations alluded to by the petitioner. Article 1(4) and 36(1) of the Uganda Constitution would appear to relegate matters that require the individual participation of Ugandans to specific questions framed under national referenda. 8. Article 36 ought to be construed within the confines of the sovereignty of the people and their right to express themselves on how they should be governed, as articulated in Article 1(4) of the Constitution. The right of sexual minorities to participate in legislative decision-making processes would similarly be by representative participation through their elected representatives, as well as the submission of views to the applicable committee of the House. The evidence on record depicts overwhelming support for the bill at committee stage and in the full House. Therefore, we do not think that more extensive consultation with sexual minorities would have led to a different legislative result. Consequently, the committee cannot be faulted for considering it neither expedient nor necessary to engage in further inquiries on the bill, as it is well entitled to do under Rule 129(2) of the House's Rules of Procedure. We therefore find no violation of Articles 1, 2, 20, 36, 38, 79, and 94(1) of the Constitution. Issue number 3 is resolved in the negative. Issue number 4, conduct of the Speaker of Parliament. The petitioners contend that the conduct of the Honorable Speaker of Parliament during enactment of the Anti-Homosexuality Act influenced the debate on the bill under 77 of the Parliamentary Rules of Procedure, which prohibits the Speaker from participating in parliamentary debates. Meanwhile, the conduct of parliamentary debates is not addressed in the Constitution, but under Part 12 of the parliamentary rules of procedure. 10. We do not think it was the intention of the framers of the Constitution that every flaw arising from parliamentary rules of procedure would constitute a constitutional violation simply because the rules were enacted under Article 94(1) of the Constitution. Whereas the Speaker's conduct might indeed have Are we still okay? Whereas the Speaker's conduct might indeed have depicted undue partiality, that would have been a matter for the House itself to address under its procedural rules. A violation of Rule 77 of the Parliamentary Rules of Procedure would not amount to a constitutional violation. 11. The case of Honorable Francis Zake versus the Attorney General, Constitutional Petition number 3 of 2022, and reported, is inapplicable to the circumstances of this petition. The bone of contention in that case was the impropriety of the Speaker presiding over a matter in which she was a de facto complainant. In this case, however, it is her alleged partial guidance of the House debate that is under challenge. We therefore find no violation of Article 89(1) of the Constitution. In the result, we find no merit in issue number 4 and hereby resolve it in the negative. Issue number 5, constitutional prescription against same-sex marriage. It has been alleged that the procedure adopted by the House during that constitutional amendment process violated Rule 126 of the Parliamentary Rules of Procedure and therefore Article 94 of the Constitution. However, the affidavit evidence of the Clerk of Parliament establishes that there was no breach of Rule 124. It demonstrates that after the first reading, the bill was sent to the Legal and Parliamentary Affairs Committee. After the second reading, the bill and the report of the committee came up for debate before the committee of the whole House. Honorable Abdu Katutu moved a motion for Clause 11(2)(a) of the bill to be made prohibitive rather than regulatory, hence the introduction of Article 31(2)(a) of the Constitution. There is nothing on record to suggest that the bill at the second and third readings was not supported by 2/3 of the MPs present and voting, as prescribed in Article 26 of the Constitution. The fact that the committee did not specifically recommend an amendment to Article 31 of the Constitution neither barred the honorable members from moving his motion or the House from considering the motion. Parliament reserved the right to accept, reject, modify, or amend the committee's recommendations. We therefore reject the view that Article 31(2)(a) of the Constitution was enacted in breach of Article 1, Sub-Article 1 of the Constitution and Rule 124 of the Parliamentary Rules of Procedure. We find no constitutional violation of either Article 1, Sub-Article 1 or Article 94, Sub-Article 1 of the Constitution. With regard to the alleged breach of Article 44 of the Constitution, we found no evidence whatsoever of the inhuman and degrading treatment occasioned by the prohibition in Article 31(2)(a) of the Constitution against same-sex marriage. The best evidence in this regard would have been from persons that have been denied such a marriage, but none was forthcoming in this case. We thus find no merit in this allegation, and accordingly find no violation of Article 44(a) of the Constitution. Issue number 5 is accordingly resolved. Issues. Issue number 6, principle of legality. The principle of legality is enshrined in Article 28, Sub-Article 12 of the Constitution. That constitutional provision was interpreted in Attorney General versus Salvatore Abuki, 1999 Uganda reports to require the legislature to legally define a criminal offense without necessarily defining each word in the law. The principle further proposes that where a statutory provision is not vague or ambiguous, it would be constitutionally valid. But where no intelligible standard can be deducted from the wording of a statute, there would be no legally defined offense as required under Article 28, sub-Article 12 of the Constitution. In this case, we read no ambiguity in Section 6 and Section 14 of the Anti-Homosexuality Act. Furthermore, the cross-reference to the rest of the article under Sections 9, 14.1 and 15.1 of the Act in order to ascertain other criminal offenses thereunder would not in itself render the impinged provisions vague or ambiguous. Similarly, Section 7 of the Act clearly creates the offense of publication of a victim's identity and prescribes the penalty thereof. Although not defined in the Act, the technical term trimedia faristis simply relates to the tripartite broadcasting mediums of television, radio, and print media. Given that these are typical broadcast and publication mediums, we find no uncertainty in the reference to that term. 17. It is the duty of courts to construe statutes so as to give effect to the objective of legislature and do justice to the parties. It is only where the ambiguity or uncertainty defies judicial interpretation or is incapable of meaningful construction that a statutory provision would be declared void on account of vagueness. In this case, the plain, natural, and ordinary meaning of the key words in Section 11 of the Act is sufficient to clarify the nature of the conduct that is prohibited under subsections 2A, B, C, D, and E of that statutory provision. On the other hand, Section 14 entrenches the mandatory reporting of suspected offenses under the Homosexuality Act. We do not find any ambiguity or uncertainty in the evidential standard of reasonable suspicion either. It simply denotes suspicion that is grounded in bona fide, genuine, and objective reasons. That would negate any malified and subjective reporting that is prescribed under Sections 15 of the Act. We are satisfied, therefore, that Sections 14 and 15 of the Act are neither contradictory, nor vague, nor uncertain. We therefore resolve issue number 6 in the negative. We shall commence our interrogation of the rights that have been involved under issues number 17 to 15, number 7 with the explanation of issue number 8. Issue number 8 is on human dignity. The petition has contained that some provisions of the Anti-Homosexuality Act are inconsistent with the right to human dignity and protection from inhuman treatment. Under international law, the concept of dignity is broader than the imperative of respect of human dignity that is encompassed in Article 24 of the Constitution. Rather, dignity is considered to manifest as a right, a principle, or a legal value. The petition before us invokes human dignity as a substantive right that is the fundamental source of human rights. 20. The evidence on record is that the Anti-Homosexuality Act was enacted against the backdrop of overt superimposed homosexuality on Ugandan culture by the recruitment of children into the practice. The anti-homosexuality law thus sought to reflect societal sentiments on the subject of homosexuality. We take the view that the right to dignity ought not operate in the abstract, but within the societal, political, cultural context of a society. particularly their communal culture, norms, and values. It follows then that conduct that deviates from the cultural manifestation of any life, language, literature, music, religion, traditions, and customs operates at cross purposes with the right to human dignity. In Uganda, such societal considerations are stipulated in Article 8A, which ties the governance of the country to national interest and the common good, as opposed to individualistic considerations. In addition, Objective 24 of the National Objectives and Directive Principles of State Policy obligates the state to promote and preserve such cultural values and practices as envisaged as the collective dignity and well-being of Ugandans. This state obligation is echoed in Objective 14A, which obligates to ensure that all development efforts are directed at ensuring the maximum social and cultural well-being of the people. Furthermore, this court is under Article 126, Clause 1 of the Constitution, obliged to exercise its judicial power in the name of the Ugandan people and in conformity with the law and with the values, norms, and aspirations of the people. Uganda's social cultural norms, values, and aspirations are summed up in Objective number 19 of the Constitution's National Objectives and Directive Principles of State Policy, as well as Article 31A, 2A, and 37 of the Constitution. There is no global consensus on the universality of the rights grounded in sexual orientation, gender identity, gender expression, sex characteristics. Hence, to date, non-discrimination on the basis of various variables not found to international human rights treaties. It has been vetoed by a bloc of resistant UN member states that has prevented the adoption of a binding declaration strengthening protection of LGBTI human rights. 23. Case law on the subject differs from jurisdiction to jurisdiction. In the case of Navitya J. Singh versus Union of India, the Indian Supreme Court held that consensual carnal intercourse among adults, be it homosexual or heterosexual, in private space, does not in any way harm the public decency or morality. That decision was grounded in the notion of constitutional morality, supposedly harmless nature of the consensual homosexual rights, and the rights to individual autonomy. However, we are unable to follow that decision for the following reasons. A, the notion of an individual's unfettered sexual autonomy defies the logic of offenses like incest, bestiality, and other unnatural offenses that are still on our statute books. B, we respectively do not share the view that the pleasure derived from an action would negate its criminality, otherwise offenses like rape and incest would be devoid of criminality. C, with regard to the alleged absence of harm in private, consensual acts of homosexuality between adults, the health data and evidence on record indicate that men who have sex with men, NSM, and transgender people are particularly at risk of HIV infection. A survey report posting that 13.7 of the ANS in Kampala, Uganda, were found to be living with HIV. Anal sex causes physical harm. HIV infection represents serious harm to physical and mental health, and they both place an increased disease burden on the finite budgets of lower income countries. It is a most legitimate and compelling state interest that would negate connotations of arbitrariness in the legislation of Uganda's Anti-Homosexuality Act. D. The Indian Constitution is fundamentally different from the Ugandan Constitution in the following ways. 1. It does not contain the equivalent of Article 8A of the Uganda Constitution that constitutionally entrenches governance based on the principle of national interest and common good. 2. Its directive principles of state policy are not just judicially enforceable. 3. It does not contain the equivalent of Article 126(1) of the Uganda Constitution, which obligates the Uganda judiciary to exercise judicial power with regard to the law, as well as the values, norms, and aspirations of the people of Uganda. 4. The Indian Constitution contains no provision that sarcastically proscribes marriage between persons of the same sex, which is an indication of the societal aspirations of the Ugandan people. We therefore find that sections 21(2)(1) to 4, 3(1), 3(2)(c), F, H, and J, 3 and 4, 5(1), 6, 9, 11(2)(d), and 16 of the Anti-Homosexuality Act do not violate Article 24 and Article 44A of the Constitution. We accordingly resolve issue number 8 in the negative. Issue number 7, right to equality and non-discrimination. 25. The drafting history of Article 21 and 31 of the Ugandan Constitution reveals that there was a deliberate omission of sexual orientation as one of the parameters of discrimination. The 2005 Constitutional Review exercise reveals that legislative views on the need to protect homosexual family has not changed. Anti-Homosexuality Act has not changed. The subsequent enactment of the Anti-Homosexuality Act affirms this view. The legislative background distinguishes the Uganda constitutional dispensation from the one of Kenya, South Africa, and India. Consequently, we do not find that sections 1, 2 to 4, 3, 1, and 3, 2C, F, H, J, 3, sub-article 3 and 4, and 6 of the Anti-Homosexuality Act contradict the right to equality and freedom from discrimination guaranteed under Articles 21, 32, 43, and 45 of the Constitution. On the other hand, the disqualification, these sexual convicts from employment in child care institutions under Section 12 and 13 of the Act is, in our view, intended to protect children and vulnerable groups in society. This is a legitimate objective under Article 17, sub-Article 1C, and Article 34(7) of the Constitution. Therefore, that limitation on the right to non-discrimination is proportional to the child protection objective of Anti-Homosexuality Act. It is demonstrably justifiable in a free and democratic society as envisaged under Article 43(2) of the Constitution. Issue number 7 is accordingly resolved in the negative. Issue number 9, the right to privacy.
Steve, well done. Thank you. Well done. Congratulations. And then with Steve. Yeah. Steve, you
that we came to this court with very high expectations, expecting that the judges of Uganda will stand above cultural prejudice and bigotry and make history. Unfortunately, the court, in its wisdom, has failed to stand beyond and above our cultural prejudices and our bigotry and has gone with the public sentiment. But what we have witnessed in court is what I would call a temporary reversal in an overall strategic battle or strategic war against cultural bigotry and prejudice. So we are going to appeal to the Supreme Court, not for striking down different components of this law, but for overturning this law in its entirety. The judgment that was read today, I would compare it to the judgment in the case of Dred Scott in 1857 in the United States. A black man went to the US Supreme Court asking to be freed from slavery. The court at that time, reflecting white supremacy and bigotry, ruled that Dred Scott was a property and that under American Constitution, every American citizen was entitled to a right to property. A slave was like a horse, a chair, or a goat that you owned in your house. The same Supreme Court sat 100 years later and struck down its own judgment. I am hoping that it will not take Uganda 100 years to strike down Dred Scott 002, which was delivered in 2024. The other one was actually March 1857. This is April 2004. So we are going to go to the Supreme Court, and I have full confidence that the judges of the Supreme Court will stand above our cultural bigotry. They will stand above our prejudices, our cultural prejudices, and protect the rights of homosexuals to live their lives as they wish. Let me give an example as a journalist. I don't need to be a lawyer to say the current law says that if you defend homosexuality, you have committed a crime. I am a journalist. So right now, under the law, I have committed a crime to say that homosexuals should be given their rights, because that can be construed to be promoting homosexuality. No. But that is what the court has said. So now, we will go to the Supreme Court and check on that. Is that really accepted? Two, to say that a human being, because they are homosexual, should be denied the right to housing is absurd. Can you stop heckling? You can come. So please be civilized, but you are much better than that. Yes. So I was saying that we will go to the Supreme Court because I have faith that the Supreme Court of Uganda cannot say that in a debate on sexuality, only one view is constitutional, the view of saying homosexuals are evil and should be hanged. That anyone who says that they're human beings whose rights should be respected is committing a crime. The second thing, I was so shocked that the Constitutional Court of Uganda, the judges, said that this law was made to protect children. In the 2002 police report, there were 13,000 cases of child abuse reported in Uganda. 13,000. Only 300 were of men molesting boys. 12,700 were of men molesting little girls. If our parliament is serious about protecting children, we need to protect 98% of the girls who are being violated by heterosexual men. Even before we think of the two, even though we must think also about the 2% who are violated by homosexual men. So the biggest scourge of child abuse in Uganda is not homosexuality, it is actually heterosexuality. The second thing, Let me come to the second point I was making. The second point, which I found absurd, is that the Constitutional Court of Uganda, led by one of the greatest legal minds, Richard Butera, with my friend Gash on that court, with Kiriawire, whom I saw there, that they could make a judgment that there is recruitment in schools. This country, let me tell you, has ISO, has ESO, has CMI, has Police Special Branch, has Crime Special Intelligence, has CID. It has all arms. Even State House has its own intelligence organization. Not once has one human being been arrested for recruiting children into homosexuality. This was a court judging on the basis of prejudice and ignorance. If there was a massive campaign to recruit children in schools into homosexuality, how come we have not had one person, one human being, arrested, paraded before the courts or before the press for this recruitment? How can recruitment have been taking place for the last 17 years and not a single person has been shown? So I was so shocked that our judges could judge that way. I don't know the reasons they did so, but I'm really disappointed. So because of these reasons, we shall go to the Supreme Court and challenge this law. We will even challenge it in the highest court on earth, or in the universe, that is before God. Now, folks, if you have questions?
Yes, but I asked you
Yeah.
that there were some partial issues that were given.
For striking down certain provisions of the law, like the law on health. But I felt the judges were not even strong enough on that. If you say if a person has a medical problem and is homosexual, to deny him health is absurd. So I congratulate and salute the judges for doing that. Sogala Luganda lulungi. Kakati ekyenjagala kugamba nti yes. Feba petitioners. Tugenda omu Supreme Court okuchallenginga judgment eya Constitutional Court olwaleero. Tuva wano tugenda mu Supreme Court and we are hopeful tujja kuwangula. Kakati abajaji baffe bayogeranga, I can't say it in Luganda because they themselves declared that they are making this judgment on the basis of public sentiment. How can a judge make a judgment on such an important matter based on public sentiment rather than on the Constitution?
Society that discriminates against any member, any number, any person in its ranks is not a society worth living in. And we are not available to live in a society that oppresses its minorities, that discriminates against its minorities. This is just the beginning of a long and protracted battle. Thank you very much.
Robert Rutalo, nga nze omu ku ba petitioners oba abawaabi musango guno kooti gwegobye olwaleero. Njagala okutegeeza eggwanga nti ffe ng'abawaabi tetuli basanyufu olw'ebyo kooti byesazeewo, kubanga tukkiriza nti kooti byesazeewo ebadde teyeesigamye nnyo ku mateeka nga bwe gali, ne yeesigamye ku ŋŋambo n'ebyo ebyogerwa nti waliwo ekibinja ky'abantu ekirikuluutinga oba ekiwandiisa abaana ab'amasomero okuyingira mu nkola eyo gye bagamba ey'obusiyazi, naye ng'ate tewali bujulizi bwonna bulaga wadde omuntu omu eyali akwatiddwako ku musango ogwo. N'olwekyo tusigadde twemulugunyiza era tuli basanyufu olwa judgment eno. Tumaze okukkiriziganya ng'abawaabi okuteekayo okujulira mu kooti enkulu eya Uganda eya Supreme Court era tugenda kujulira ensala ya kooti eno. Tulina essuubi nti Supreme Court ejja kusazaamu bino ebya kooti eno etaputasa mateeka byesazeemu kuba ebadde n'ekyekubiira. Yes.
Something very important. This is a message to Western human rights organizations and Western embassies and Western governments. This is a Ugandan struggle not yours. We really, really appreciate your solidarity, but we kindly request you to keep out of this business. Because when you come in, you distort the debate. Then Ugandans and other bigots begin thinking that this is something the Western world is trying to impose on Uganda. So if you can keep out of our debate, our local debate, if you can keep quiet, if you can express your solidarity silently, quietly, and in your heart, we will be very happy. We don't need any fifth Calvary from any country, from the United States, from Australia, from Europe. We don't need anything. Banning Ugandan homophobes from traveling to your countries. Stop imposing sanctions. Because when you do those things, you are simply telling the Ugandan public that this is not a Ugandan issue, it's a Western issue, that it is the Western countries trying to impose using sanctions, using cutting aid, using threats, using blackmail, trying to impose a different cultural practice on our society. Please, I beg you kindly, keep.
If you say you cannot practice your profession, what is there to say you have a right to health? I think that it is an attempt at the court to throw some positive news in what is really a very bad judgment. As a lawyer, you come to court expecting the court to apply the law. You come to court expecting the court to rise above populist sentiments in the public. Unfortunately, on this occasion, this court played to public sentiments by quoting public sentiments, by quoting unverified, unsubstantiated allegations of recruitment of children into homosexuality. To that extent, the court was disappointing. But nonetheless, the court's decision must be respected, even if, like in this case, we disagree with it. I think that we will look at the judgment, study it, and quite possibly take this to the Supreme Court, because you cannot allow this kind of judgment to remain on the law books. That a court of law is citing unverified allegations, is citing public sentiments, is citing unverified customs and customary values of a very diverse society. I think that that is disappointing. But nonetheless, we'll take this challenge to the Supreme Court and see what the Supreme Court will say.
There are sections where they...
Well, what is there to say you have a right to health when the court itself is confirming legislation that denies your existence? The court does not acknowledge the rights of LGBTI individuals to organize, to be able to participate in their own governance. In fact, the court even said they were not even if they had consulted them at Parliament, would be useless because it wouldn't change the outcome. The court is denying your existence to participate in that process. And what is there to say you have a right to health if the court is legislating away your very existence and your very right as a community? So it is really an attempt by the court to throw some things at the public to try and ameliorate what I think is a very poor judgment on the part of the court.
And also to ensure that our families are thriving, because family is a foundational institution in society. There's no way that homosexuality and families can live side by side. It is impossible. Either families thrive and homosexuality falls, or homosexuality rises and families fall down. So since we are a pro-family nation, we are a pro-life nation, we cannot involve ourselves or welcome something like this which is destructive to the individual, destructive to society, destructive to life. So we are really happy with the court system. Thank you very much. Langa, and I'm one of the people who has stood to defend the law. I'm happy today with the ruling of the court in principle regarding the anti-homosexuality case or petition which was brought, where the petitioners wanted to strike out or to strike down the Anti-Homosexuality Act or law. So in principle, today the justices have retained or maintained the law. And secondly, they have also said that there should be no injunction, or they will not welcome any injunction to stay or to hold on to it while the matter is still being handled in other fora. That was decided, and so we are really happy about that. Because as far as we are concerned, homosexuality destroys individuals, homosexuality destroys families, homosexuality destroys society. This is something that actually destroys civilizations, and we can see from history, there's no civilization that has survived homosexuality. So because of that, we don't want to follow those countries that have decided to do it. We cannot go and be led to the ditch when we are watching. So because of that, we are really happy about that. There was a small section about health and also about privacy and renting homes and so on, where the court said that, okay, maybe they should be allowed to do that. But well, we are going to look at it. We are going to study. Our lawyers are going to look at it, and we are going to give our response to that. If we need to go to the Supreme Court, we are going to go to so that we defend our families, we defend our children, we defend our nation. The time has come when Africa needs to stand on her own feet and chart out her own course and destiny. We cannot be colonized again sexually or colonized again culturally. We refuse that. It's time for Africa to now take our own course in our hands, our future in our hands, and this is it. We are moving forward as Ugandans. Thank you. My name is Stephen Langa.
I was disappointed I didn't have a chance. I was disappointed because many people are talking about World Bank, that we can't afford the law, that they are not going to give us money. But the truth is, we can't afford LGBTQ. And to me, it was a perfect moment in court to interrogate Pepe Onzima. How much did she spend on getting a sex surgery? The average sex surgery is about $25,000. Now, if only 1% of Uganda's young people take gay identity, LGBT theory, and they take sex surgery, that's $25,000 times 500,000 people. Uganda can't afford those billions. Not only that, they must have a lifetime of hormones, they must have a lifetime of gels, they must have a lifetime of steroids. This is big pharmaceutical, hooking our children to this. The second thing we can't afford is HIV/AIDS. The new HIV/AIDS law means that Ugandans are the ones who are supposed to pay for treating people with HIV. Me, my brother Steve. Now, if more people get HIV, that means the taxpayers are mandated to pay. And many of you know we are struggling to raise taxes. We are told that people who practice homosexuality are 10 times more likely to get and spread HIV. This is a study all over sub-Saharan Africa. 2009, the Lancet magazine published those papers even up to today. Any group that is 10 times, that's 100% more likely to have and spread HIV. The average cost of treating someone with HIV in America is $50,000 per person. 50. If only 10% of Ugandans get HIV as a result of this, we are going to be bankrupted. So the judgment today was protecting not only our culture, but protecting Uganda from sliding into economic bankruptcy, spending malaria money in buying sodomy girls. We can't spend money of helping women to give birth in sex changes. So I really missed my day in court because I wanted to ask Pepe. I wanted to ask Andrew Mwenda. Andrew Mwenda, in what capacity do you defend homosexuals? Are you yourself a homosexual? How do you speak for them? Because we have seen many people come here, including Andrew Mwenda, crying, oh, you can't do this, you can't. But Andrew Mwenda, in what capacity do you speak for homosexuals? Are you yourself a homo? Or you are not? Are you paid to be? So I did get that chance to ask Andrew Mwenda. Badde ntambula ate kakati munkyusa banange okusooka nebaza abalamuzi bano abasazeewo singa Pepe badde ya 100% tukoze 95 etteeka likyaliwo balese reason after reason simanya tewali sente kulabirira basibe ne bagande sente jeziri akale simanya freedom simanya bichi kalicha era bagande no terimenya mateeka wabula ekinsubye mbadde njagala kubuuza oyo oba mulenzi gwe twali tumanyi ng'omuwala pepe onzima tumubuuze sente mmeka ze baakukozesa okusalako amabeere sente mmeka ze baakola okusitalamu n'abaana buli lunaku omira mpeke ki okusobola okubeera ng'ofuuka manyi babiyita bi steroids mwe abakola sports mubimanyi ba steroids gayamira empeke n'afuuka ki masikula ate kasita ozirekera ng'oddayo kati okuyigiriza abaana baffe eyo gye bayita simanya ge LGBT singa just 1% abaana 5,000 bayingira nti nange njagala kunsala amabeere nange njagala kunzegyamu n'abaana mumanyi nti no buli kimu kikozesa $2.2 $25,000 okukyusa sex change. We can't afford that. Number 2, abantu bano balwala siriimu. Okujjanjaba omuntu siriimu buli mwaka $5,000 mu Amerika. Kati siriimu atambulanga tepya omusezi nga alabye omufu. Mukiwulira? Kati ekintu nyo teruliko nti baagala tuleetera siriimu tetusobola kuba na ssente kujjanjaba abantu siriimu. Balina bino ebinaaka ebizigo bye beeteekamu bya ssente. Tetulina ssente za malaria tugende tunoonye ebinaaka n'ebidomola bya gundi bya bino babiyita biki bijerejere katandika okuleeta nga tukola importing ebizigo. Banenya kubuuza ne Andrew Mwenda ayogerera abasiyaga obwogerera ngani oli musiyaga oba bakuwa appointment nti official spokesperson of abasiyas era ntutwamusaba ave ne MK movement kubakade ekintu ekiriwo mulaba nti people power eri ku minzaane kiki bagipima people power enefukanga AF ono Malema mwamulabe yalwanyisa etteeka kubanga awagira bisiyaga kati era olutalo wakati wa Bobi Wine n'empuuga tuli ku kintu eki ani awagira ekisiyaga nitakiwagira era olaba ne wano ne mu MK ne mu NRM tulina ne bano ba Andrew Mwenda batuswaza abantu abo twatuswaza twandibali tukolayo omukolo ogw'abakadde tulina kukolayo cultural event tuyita abavubuka bano bonna babadde mu bisiyaga tubagobemu emizimu nti fire in the name of Jesus, fire in the name of Jesus. Akayimba kaffe tugenda kayimba tubiganye siyaga tubiganye aloge tubiganye Sodoma tumuganye aloga tubaganye basodoma tubaganye aloge Uganda Uganda families Sodoma zi ebisiyaga zi Uganda alo